We're here for the Smith versus Smith, order to show cause. Please be seated. Counsel, will you make your appearances?
Eric Johnson on behalf of Mr. Smith, who is present.
Good morning, Your Honor. John Coy on behalf of the respondent, Penelope Smith.
Mr. Johnson, this is your motion. Please proceed.
Thank you, Your Honor. Just to respond to those things then. There was a question about Mr. Smith's work schedule. He does not work beyond 5 o'clock. There may be times occasionally when his shift will end at 5 o'clock where he has to shut down or he has to file a simple report, but that just takes a few minutes. For all intents and purposes, his work schedule ends at 5 p.m. It does not shift, it does not change, and he does not work late. I will point out that Mrs. Smith does work outside the home, and that by the time she's off work, she actually spends more time getting back home than Mr. Smith would because he works in the same place where he lives. I want to point out also that this question of the bond and things of that nature, there's no evidence before the court that would establish that objectively. The children love both parents. I don't think there's any dispute about that. The children have a bond with both parents. These are 3 boys. They need their father. They love their father. The oldest child spends most of his time since the separation actually spending the time at my client's house, in his apartment. He spends most of his time and most of his overnights there getting himself back and forth. The other 2 boys love both parents. We see no reason why the divorce of 2 spouses should mean the kids divorce their parents. There's no reason for that. This is temporary orders, and if for some reason the children are shown to be suffering in a joint custody arrangement, we can always come back and ask for a modification of that situation. But I don't see why we would not give joint physical custody a losing chance, at least, at this temporary level. I wanted to point out that, yes?
And so what have been the arrangements since the separation? Can you please remind me?
Well, there hasn't been any formal arrangement. There's no agreement they've had, and so the 16-year-old has a driver's license. He can drive himself back and forth, so he's more autonomous, and he spends most of his time at his father's house. But we don't mean to imply by that it's because he doesn't like his mom. He just likes to spend time at his father's house. He has his own room there. The other 2 boys are in the other room. Mr. Smith is in his own room where he has his office as well. So right now it's been back and forth. I will say that the children have spent more time with Mrs. Smith than with Mr. Smith, but that's over Mr. Smith's objections. He doesn't like it that way. It's why we're here today, because we could not work out an arrangement that is satisfactory to both parties. Right now, though, they've been spending more time at their mother's home than they have spent with their father. Do you have any other questions? Does that answer your question, Your Honor?
I'm sorry, please.
No, I appreciate that. There's the issue of Mr. Smith's DUI conviction. That was 6 years ago. It's not as though it was a low blood alcohol content. He has a perfectly clean criminal record. He's not somebody who goes about doing a lot of other reckless things. This was a mistake. He acknowledged it. He took care of everything. He complied with all the requirements of his sentencing. And that was 6 years ago. He hasn't had any trouble since. It was unfortunate, but certainly aberrant behavior and not something that would indicate that Mr. Smith has a drinking problem. I would proffer that if Mr. Smith were called as a witness, he would say that he is not a drunk, that he does not abuse alcohol, that he's not an alcoholic. He will occasionally drink. He will drink at home, but there's nothing wrong with that. It's not illegal. He doesn't have a problem. If anyone has any question along those lines, Mr. Smith has told me he'd be more than happy to submit to a drug and alcohol screening. There's just nothing there, Your Honor. There's also the matter of the allegations of pornography. Your Honor, this is troubling to me because, like it or not, pornography is legal. There's no allegation that Mr. Smith is engaging in any kind of illegal consumption of pornography. He does have some pornographic material on his computer. There is no dispute that the children have not been exposed to this or that they will be exposed to this. If there's any question, Your Honor, the computer that this is on uses the same biometric scanner as Mr. Smith's work computer. They are not the same computer. Mr. Smith has his own personal computer, password protected, and he has to scan his thumbprint in order to get into it. The children don't know Mr. Smith has this account. Mr. Smith does not share that with them because he doesn't feel it's appropriate the children should know. But the idea, frankly, I'm disturbed by the idea that they would raise this pornography question when in fact they themselves know Mr. Smith doesn't have a pornography addiction and does not expose the children to pornography. It's legal for him to consume that just as it's legal for Mr. Smith to drink or to smoke or do many other things that some people may disapprove of. It's a legal activity. It is not adversely affecting his ability to be a parent. And we would submit, Your Honor, that it's irrelevant to the question of custody. We will also point...
You're saying zero chance that the children are going to be exposed?
Oh no, there's of course there's not zero chance, just as one of the kids could get into the refrigerator and crack open a beer if they want to, which of course is not unheard of in real life. What we're saying is to bring up the issue of pornography would be like saying there's also a chance that Mr. Smith may start smoking marijuana and then hand his kids a joint. There's no connection between the facts and what they're fearing is going to happen. Mr. Smith doesn't hide the fact that he has access to pornography, but he takes appropriate safeguards so that the children will not be exposed. And I will note conspicuously that Mrs. Smith does not accuse Mr. Smith of being reckless or somehow accidentally or intentionally exposing the children to pornography. It's a red herring. In fact, I don't want to talk about it anymore. Is there anything Your Honor does want to ask me about that? So I want to point out that Mrs. Smith they have the same schedule when it comes to work. Mr. Smith and Mrs. Smith work a 9-to-5 job, essentially. So to suggest that one has a better schedule than the other simply isn't the case. Mr. Smith works from home. There was a question about when the kids can get to school. Mr. Smith can be up at the same time the children are and get them to school just as easily, if not more easily, than Mrs. Smith. The only...
So where does Mrs. Smith's allegation I seem to have heard something about early mornings being a problem for Mr. Smith.
Right.
Am I mishearing that?
No, that's what they said. There's just no substance to it. There's no evidence in the record to support that, and Mr. Smith categorically denies it.
Okay. I'll
Right.
ask him about
They're
that.
positioned the same way. Mr. Smith and Mrs. Smith are roughly the same distance from the school. Mr. Smith does not work late nights. Mr. Smith has no reason why he would ever get up late or anything like that. So the allegation is just an allegation, but nothing more. In conclusion, Your Honor, the only thing we wish to bring to the court's attention is that we do have some concern about the mom's boyfriend. She has been seeing a man that we know by the name of Jerry. We don't know much about him. We are concerned, however, that he's spending at least 2 overnights each week at at his girlfriend's house.
That's not true.
And excuse me, Your Honor.
You can have your counsel speak for you. I'll have him speak in a moment.
And so we do think that if she's going to start to raise concerns about this drinking or the pornography, I mean, she's no innocent herself. And we don't have any reason to believe that Jerry is a danger to these children. We do have concerns, however, that it's a bad moral example to have their mother, who is still not divorced, or even when the divorce goes through, to be having someone else staying the night with the boys in the same house. We think that we simply can deal with that, though, by having an order that when the children are with their parents, that no romantic interests, boyfriends, girlfriends, or people to whom they're not married can be staying overnight. And that's how we ask to address that. Are there any questions, Your Honor?
No, Mr. Coy, it's a response to the
Yes, Your Honor, thank you. There are, of course, a number of things that I want to respond to that have been raised by opposing counsel. I'm going to start, though, with more or less what I heard as an admission with respect to the pornography issue. He indicates that it's legal and that they don't perceive it as a real risk to the children. My client's concerns are legitimate. The world of technology is not a perfect world. What might seem secure today might not be secure tomorrow. Certainly, it's a concern. And as the court knows, the issue of the moral standards and how it impacts on the children is a real issue. We think the alcohol is also significant in that regard. Particularly, they raised issues about my client's boyfriend, and she does have a boyfriend, but it's not true that he overnights at the home. There have been a handful of occasions since the parties have been separated where, because of circumstances, that he did end up having to stay a night, but he didn't stay in the mother's bedroom. It didn't raise concerns with the children. They're familiar with Jerry. They're friends with Jerry. They like Jerry. This is a typical situation where the father is uncomfortable, that there might be eventually at some point be another man in the picture. Probably he feels threatened by that. It's a normal reaction, we understand, but it's not a concern. In fact, it shouldn't be a concern to the court as far as the children as far as how it affects the children. They get along well with Jerry. And again, as I stated, there's no impropriety that is hanging around the house in the children's minds. He's there at appropriate times. He does not generally stay overnight. Like I said, in the course of 5 months, maybe 2 or 3 times he stayed over, but he had to make separate. He did not stay in the bedroom with the mother. To the point of the accommodations, the children at the father's house, there are 3 bedrooms. The father has his own bedroom, the oldest child has his own bedroom. The younger children have to share a bedroom. They're 7 and 13, and at that age, they'd be better off staying in the arrangement that they've had up until this point, where the children have each had their own bedroom. That has been the case at the mother's house. The mother has stayed in the family home, in the marital home, and finally, just as further indication that the children are more comfortable there, notwithstanding the fact that the older child likes to go to his father's, and frankly, the reason for that is an older child at 16 years of age likes to be in a place where maybe there aren't as many rules, maybe not as many chores, the other children not around to have to bother him all the time. A 16-year-old is going to go where he wants to go, and the mother respects that and lets him have that relationship with his father. But he goes back to the mother's house to overnight. He goes to his dad's after school. Sometimes he'll stay for a period of time, but he typically comes back to the mother's house, and that's where he stays overnight, and that's where he leaves to get ready and go to school. So with that, I think I just want to reiterate the fact that the children do have a stronger bond with the mother. It's not as though they don't have a bond with the father. That's not the issue, but it's not the same relationship. There's a reason why the children are with the mother. It's not just because it was under protest, as the father says, but that's what the children wanted to do, and that's where the children should stay, because they're going through enough right now already. Opposing counsel correctly points out that there may be future opportunities to make adjustments if we need to. Right now, there's no need to do that. But the court is going to have an opportunity to review this. Either the parties will reach an agreement, or eventually this matter will be resolved at trial. So one way or another, there will be an opportunity to continue to see how this process is going. Right now it's going well, and it just doesn't make sense to upset the apple cart when the children are already going through enough. They should have as much stability as they can, and that's what they have right now, living with their mother full time. Thank you, Your Honor.
At this time, I am denying the motion for order to show cause. I do find it deeply troubling that Miss Smith, did purchase the tickets in such a timely manner when he was running just a little bit late, but I don't feel that it was something that was intentional to harm the relationship, to defy the order. I also find it deeply troubling that we're here on this type of issue when it's something that easily should have been resolved between the two of you, whether that's through counseling, whether that's through mediation. That's something that I'm going to recommend. I'm not going to include that as part of my order, but I do recommend that you do seek out some type of counseling so that you can learn to co-parent. The court is not here to listen to matters such as two parents just not getting along when they're running 20 minutes late. I will go ahead and ask Mr. Coy to prepare the order.
Okay, thank you, Mark.